Hello, everyone. I'm Leslie Rohde with AskTheLawyers.com. And today we're speaking with attorney Steve Nagle, who is based in Austin, Texas, who is a specialist in personal injury. He commonly helps people dealing with all types of insurance claims. We're talking about car accident claims, health insurance, life insurance, homeowners insurance. Now, sometimes people may start filing a claim like this on their own, and then they need some legal advice. So we're happy that Steve is with us today to answer some common questions. Thanks for being with us, Steve.
You're welcome, Leslie. It's good to be here.
Now, you're a specialist in personal injury. Tell us what that means.
Well, in Texas, we have a board certification process. In order to become board certified in any particular area of the law, you have to take a test and you have to show other qualifications. I've been board certified in personal injury trial law since 1985, which was almost when they started the program. They began the certification program in the early 80s. And there are certifications for a number of different areas: real estate, probate or estate law, and quite a number of other different areas.
We mentioned the insurance claims that you help people with. Do you always need a lawyer when you're dealing with an insurance claim?
No, of course. Many people handle their insurance claims without help from a lawyer, and for most purposes, a lawyer is not necessary. However, when your insurance company denies a claim and you think it's unreasonable or that the insurance company is taking some sort of unfair advantage, it is a useful and very good thing to talk to a lawyer at that stage.
Are there any red flags that people should watch out for other than that, that denial of a claim that should cause you to get an attorney involved?
No, it's kind of a moving scale. Some claims are too small to justify a lawyer's involvement because a lawyer at that stage is mostly going to be paid by an hour. And of course, spending $250, $350, $400 an hour on a lawyer is not worth it if your claim is $75 or $150. On the other hand, once your claim gets up to $2,500, $5,000, or significantly more than that, if you're talking about $50,000 or $100,000 or more, then certainly it's worth getting a lawyer involved.
So is there any type of insurance claim, though, that you should get a lawyer involved always before you make the claim, not after?
No, although the more complicated claims it's useful to consult a lawyer. It's not necessary, but the more complicated the claim is, the more complicated the forms are that you have to fill out, the more useful it might be to consult a lawyer before you file a claim. If you think it really comes down to this: if the claim is big enough and you're worried about how your facts fit into the claim and whether your claim fits under the policy, it's a good idea to talk to a lawyer before you make the claim.
I can understand that. Okay, we hear the term insurance bad faith. Can you kind of help us understand what that is? Maybe give us some examples that you've seen?
Sure. Bad faith is something that the law recognizes as a result of the unequal relationship between insurance companies and their insureds. You have to understand, every claim does not necessarily involve bad faith. In the way lawyers look at things and the way insurance companies look at things, there are two basic classifications of claims. One is a first-party claim, where you bought the insurance policy. It's your homeowner's policy, your automobile insurance policy, life insurance, accident, disability insurance, those sorts of things. The second type of claim is where somebody else caused a harm to you. That's where you're in a car wreck and you're making a claim against the other person and their insurance company. Or you slip and fall in a store and you make a claim against the store. Those are called third-party claims. And while the insurance company may treat people unfairly in those claims, that is not considered bad faith in Texas because there is no first-party relationship. Bad faith requires a first-party relationship. That is, you have to have purchased either directly or through your employer the insurance.
So actions of the insurance company, when would they rise to the level of bad faith? In just that incident?
Well, no, what bad faith amounts to is it's something akin to what people may have heard of about breach of a fiduciary duty. A fiduciary is somebody who has a special responsibility because of an overpowering relationship, a relationship of trust. Trustees have fiduciary duties. And insurance companies are considered to have a fiduciary duty to their insureds. That is, they have a duty not to take unfair advantage, not to take advantage of the ignorance of the person or the fact that the person doesn't know how the claims process work. If an insurance company takes unfair advantage, that is bad faith. And in Texas, we have additional help because the legislature has created a couple of statutes that define specific instances of bad faith. And that's a great help in many, many cases.
So that's in Texas. What about federal laws? Any kind of laws that protect people?
There are federal law is much different. Most bad faith law is a state by state thing. And there is actually a big hole in the bad faith arena in federal law because there is a federal law called ERISA, the Employees Retirement Income Security Act, which gets abbreviated ERISA, and lawyers and everybody else calls ERISA. ERISA is a program through which employers provide their employees insurance, and it can be all kinds of insurance. Most commonly, that would be health insurance, but it can also be disability insurance, life insurance, and many of the other kinds of insurance that people buy. Generally, it's not homeowners or auto insurance, but anything else that you get through your employer is probably covered by ERISA unless you work for the government, that is the state government or the federal government, or you work for a church. And the Supreme Court of the United States has determined that there can be no bad faith in ERISA cases. Even if the insurance company treats you very unfairly, there is simply not a bad faith cause of action under federal law for those violations.
So you explained what ERISA was, let us know that, but why does this law protect people from this bad faith?
Well, bad faith, people need protection from bad faith because the insurance companies have an unfair advantage. They know how the law works. They know how their insurance policy is structured. They wrote the terms of the insurance policy. Most people don't look at their insurance policy until it's time to make a claim. And insurance policies are long, they're complicated, they use legal terms, and therefore people don't understand them. And it's pretty easy for an insurance company to take advantage. They control the claims process. Since they control it, they can take advantage of it. If they do so, it's not fair. It's called bad faith. Now, there are some simple things they can do, some simple ways you can understand the bad faith. If the insurance company fails to explain a policy term in a reasonable way, if they fail to make a claims decision quickly, if they deny a claim without a reasonable basis, those are all bad faith things. And there's some also in Texas, as I mentioned, some statutory things that we can rely upon that are even more explicit than the general, what we call common law bad faith.
Can you give us some examples of things that you've seen, that you've dealt with in your practice, so that we might have a better understanding?
Yes, there are a number of different things. In the health insurance arena, for example, insurance companies tend to deny claims on the basis of you didn't supply the proper documentation, you didn't do this, you didn't do that. And of course, in health insurance, most people are relying upon their doctors or other healthcare providers. And so insurance companies can take advantage that way. In automobile insurance, under medical payments or personal injury protection or underinsured motorist coverage, insurance companies can take advantage by unfairly valuing your claim or not making a claims decision promptly. There are time limits for insurance companies to make claims in those circumstances, and usually they're in the neighborhood of 15 business days. If the insurance company has delayed beyond that, that is an automatic violation of the statute, and you can recover damages.
When should people start getting involved and call an attorney like yourself? When do they need to contact you?
Well, I'll talk about two different circumstances because ERISA has its own set of circumstances. And here I'm talking just about insurance claims, not about personal injury claims. Personal injury claims, if there's a serious injury, you should call a lawyer right away. It costs nothing. Most lawyers do those sorts of claims on a contingent fee basis, and you can get a lot of good advice just by making a telephone call. But talking about insurance claims, you should distinguish between claims that are governed by ERISA and claims that are not. In any claim governed by ERISA, if your claim is denied, there is an internal appeals process for the insurance company. And if your claim is denied and the insurance company says you've got 180 days, which is the standard under ERISA for an appeal period, to file this appeal, you should probably get a lawyer involved if the amount of money is substantial, because people don't understand, under ERISA, the only time you get to submit evidence in these claims is during that appeals process. Now, it's different for ordinary insurance claims. If your claim is not to an insurance company that you have contact with through your employer, there are different sets of rules. And there you have more time, and it's more a matter of, has the insurance company treated you fairly? Are they making the decision promptly in that 10 to 15 day window that I mentioned earlier? Or are they somehow not accepting the facts that you have presented to them? In that case, it's time to talk to a lawyer. Again, sometimes you can do that on a contingent fee basis. Sometimes it'll be hourly fee.
Good distinction to make for people, for sure. You mentioned the fees there. Does it cost more to hire a specialist like yourself?
No, generally, although it is true that specialists have more experience and our hourly rates are higher. If it is a contingent fee case, contingent fees tend to be generally within the same range across the board. And although the fees may be higher on an hourly basis, generally a good specialist is going to get you an answer to your question and either say, I can't help you very quickly, or get you your claim resolved much more quickly than somebody who doesn't have the kind of experience that a specialist has. So the fees end up being either cheaper or get you a far better result than you would have had otherwise.
Right. All right. Steve Nagle from Austin, a specialist in personal injury attorney. Thank you so much for giving us a lot of good points to think about in this area.
Thank you, Leslie.
We thank you all for watching. I'm Leslie Rohde with AskTheLawyers.com, where you can choose a lawyer that lawyers choose.